appoint an arbitrator in certain fiscal matters, in certain disputes, my lord. Now, under the original constitution, prior to the 22nd Amendment, the Chief Justice was empowered to appoint a caretaker, Chief Election Commissioner out of the judges of the Supreme Court. Under the original constitution, prior to the 17th and 18th Amendment, the Chief Justice alone acted as a consultee for appointments in the judicial.
What is the point you're making?
My point is, my lord, that when we say that the Chief Justice is senior among equals, what distinguishes the Chief Justice from the judges? Administration. Otherwise, the Chief Justice would be equal among equals.
Okay, but you are saying that because these specific provisions of the Constitution specifically mention Chief Justice, so by analogy, he has other powers as well. That's what I've understood from your argument.
By analogy, he is the senior among equals.
Okay.
And you see where there is a power under 191 to frame rules, the rules are for the purposes, administrative purposes. And in addition to the rules, there are constitutional or there are conventions of the court which have invariably been followed since the 1956 Constitution, and before that the Government of India Act. So those conventions have also acquired the place of rules, or for that matter, the procedure of the court.
Yes, my lord. Article 268(7) is very much clear to that extent, that anything having the force of law has been deemed as law,
Yes,
my lord.
268(7).
268(7), my lord. Now, what this law has done, the law does not say that the Chief Justice, in consultation with the two senior judges, shall constitute a bench. No. Had it been so, it would be least objectionable. What has been done, my lord, that any two of the three may constitute a bench. So the office of the Chief Justice has been converted into that of a senior judge, or the positions of the senior two judges have been converted into quasi-chief justices. This is my submission, my lord. There is no consultation. While concluding the arguments on the previous hearing, your lordship mentioned to the preamble, Article 2, Article 2A, 227, and I'm grateful that your lordship referred to the Grun norm. No consultation is there in this law, my lord. No consultation. And one potential deadlock which I see, not today, say 50 years from now, my lord, the two judges on one side, the Chief Justice on the other side, 50 years from now. The two decide.
Why 50 years from now? Why
My
not tomorrow?
Not regarding the incumbent.
चलें आगे बढ़े ना आगे.
मैं एक potential.
आप इतना लंबा तमलीग बांध रहे हैं.
मैं 5 मिनट में.
चलिए कह दीजिए.
If the two judges are.
हाँ ठीक है तो he'll be in a minority, big deal.
हाँ, and the two decide.
So what?
That my honorable the Chief Justice, we have established, we have created a roster, and according to that, for the next month, you will do the chamber work.
ठीक.
You will not sit on a bench.
ठीक है.
So the office of the Chief Justice has been paralyzed, my lord.
Chief Justice can do so himself.
I'm not saying, my lord.
So it implies that Chief Justice can do so, it's okay.
I'm not saying
but
this.
if two senior judges do so, it's wrong.
My lord, there cannot be any.
या तो कहें कि कर ही नहीं सकते हैं तो बात खत्म हो
There
गई.
cannot be any Supreme Court without the Chief Justice. This is my point.
We know that because the Constitution
The
says
Constitution says.
Yes.
And that would tantamount to sending the Chief Justice on forced leave. Such like enactment made by a dictator has already been nullified.
तो इसका मतलब ये हुआ कि अगर चीफ जस्टिस के पास पावर हो और वो कहते हैं कि ये दो जजेस जो है ये अगले 1 महीने तक चैम्बर वर्क करेंगे, फिर क्या होगा?
अगर कोई डिफिशिएंसी है रूल्स
अगर में चले तो अगर ये भी हो सकता है.
अगर deficiency, I'm not saying, I'm not going to the wisdom of this law. I'm referring to the potential dead end we may go into.
लर्नड काउंसिल आपने अभी तक
future का बता रहे हैं. As the law stands today, how are you inconvenienced? आपका कौन सा personal right जो है infringe हुआ है? And what fundamental right are you trying to enforce before us?
There goes, that question goes to the maintainability of the petition, my lord. And except for 3, all fundamental rights are subject to law, subject to reasonable restriction imposed by law.
आपसे simple ये
उसी पे आ रहा हूँ, my
question,
lord.
either say yes or no. Are you inconvenienced by this law?
Yes.
Has any fundamental right of yours, has it been infringed?
Yes,
And
my
please
lord.
kindly tell us what fundamental right are you trying to enforce?
Yes, my lord. I'm referring to that.
You don't want,
I have the
you
prime
don't want
right.
access to justice to be.
No.
कुछ और infringement बता रहे हैं, मुझे बताइए.
Yes, my lord. All fundamental rights except for the dignity of man and forced labor and slavery, all have been subjected to law. Now the law means
Dignity of
validly
the Chief
passed
Justice?
law, validly passed law coming from a competent legislature, that I may not be subjected to a law for which the respective legislature is not competent. This is all fundamental rights are involved, my lord. And the mother of fundamental rights, Article 4,
नहीं ये infringement का बताइए ना, कौन सा fundamental right infringe हुआ?
my lord, if the law is maintained without the necessary legislative competence, it means I'm subjected to a law for which the parliament was not competent. So it is going to affect every fundamental right.
ठीक. और कोई point?
Now, furthermore, under the constitution, all judges are equal, my lord.
जब कह चुके हैं
नहीं आगे बढ़े ना.
मैं आगे बढ़ता हूँ.
अब हमें कोई lecture ना दीजिए, जो law school में देना चाहिए, please.
ठीक है, मैं अपील पे बहुत कुछ कहा जा चुका. मैं सिर्फ एक potential misuse, My lord, under the impugned act, the committee of 3 judges may themselves sit in a bench constituted under Article 184(3). Now the judgment comes and there is an appeal stage. Now the same committee will decide as to who should hear the appeal against our judgment.
So what's wrong with that?
My lord, it amounts to appealing unto Caesar against Caesar. There is a potential conflict of interest. If I would have been a judge, I would have an interest that my judgment is preserved.
When you become a judge, we can look into it.
No.
चले.
So this,
बस.
and my lord, मैं दो points करता हूँ. As per section 77 of the Act, which says that every case having urgency or where there is a prayer for interim relief shall be fixed within 14 days. Hardly there would be a case in which there is no prayer for interim relief. So
There will be what?
in which there is no prayer for interim relief. Almost every case has a
I think
prayer.
you're mixing up the concept of interim relief with urgency.
The word interim relief has also been
ठीक
used.
है, okay. So
May I read
we
my
can apply a brain, which we do occasionally.
Okay.
And we can determine what is urgent and what is not urgent. So what's the big deal about?
What is objectionable? That the affairs of the apex court have been micromanaged. Even the civil court ordinance, even the CPC doesn't micromanage the affairs of a civil judge. It is in a way contemptuous. It is insulting. Throughout the world, we have phrases like case management, court management. These are the inherent powers. These are always left to the court, let alone the apex court.
Actually, I'll tell you what we did. I've constituted a committee for case management. So I have given my powers already to a case management committee. So you are saying that act of mine is unconstitutional?
No, my
Because
lord.
only I can do it myself, or the full court can do it.
No, my lord. It is for this honorable court to do case management. Whoever is delegated that function,
ठीक.
it is. But the law cannot micromanage those affairs.
Okay. Chaliye, next point.
Now,
your point is that by enacting this law, a power of micromanagement has been conferred on the parliament, which would open the door for it to micromanage not only these things, but subsequently any other thing that it needs to interfere with.
yes, my
And
lord.
that would affect the separation of powers and the independence of the judiciary.
Yes, my lord. And in legal philosophy, it is called the slippery slope theory.
Sorry?
Slippery slope
Slippery
theory.
slope.
Yes, my lords. Once you are on a slippery
चलिए
slope.
आगे बढ़ें.
Now, concluding my
Learned Counsel, there was a judgment from the Peshawar High Court regarding the internment centers. For the last 4 years, that petition is pending before this court. And the Chief Justice felt, many Chief Justices, that that was not an important case enough to be fixed before the court. So you justify that? You
My lord,
justify the exercise of such power?
I'm
And
affecting.
that the parliament is bereft of jurisdiction not to come to the rescue and ensure access to justice by merely regulating a discretion of the Chief Justice?
My lord,
Do you defend that, justify that?
I am the effectee of that case. I'm a petitioner. I'm
Are
a
you
counsel in that
justifying-
case, my lord.
Are you justifying it?
That again goes to the wisdom of this law. Wisdom is always with
If you are an effectee of that case and I tell you I will never fix that case, what will you do?
that would, if
No, to answer the question.
वही answer कर रहा हूँ.
If नहीं, I'm telling you, I'm saying it, I'll give you an exact
that
proposition.
would tantamount to violating the Constitution. Article 37,
What is your remedy?
37 says,
What is your remedy?
my lord, Article
None.
37 says that there
We
should
know
be
what article
inexpensive
says.
and expeditious justice.
So
So
what
if
is your remedy?
that is
Nothing.
tantamount to breaching the oath.
Yes, what is your remedy? File a reference against me.
So my lord, if
Then what will you do? Tell me.
I'll file early hearing applications.
Oh, I'm dismissed.
And
That I
if-
dismiss.
And if it
And
at
then I
all,
dismiss, then what will you
if
do?
at all it was expedient, the Constitution should have been amended. Article 55A, for instance, should have been inserted.
Okay, ठीक है.
Titled Practice and Procedures of the Supreme Court.
ठीक है, okay.
My final submission, my lord, as I said that your lordship referred to the supreme law, the Quran and Sunnah. Now, consultation is a good thing. Nothing has restrained the Chief Justice from consulting his colleagues. But this law doesn't have a single word regarding consultation. And another thing, I can proclaim with pride that those were the Muslims who introduced the office of the Chief Justice. Imam Abu Yusuf was the first Chief Justice of human history. And he was not the appellate court.
Why was he the first Chief Justice? Do you know the story? That you don't know.
I don't know the story.
Yes, because the person who was nominated did not want to become Chief Justice.
Yes,
ये भी
yes,
बताएं
yes,
ना
my
फिर.
lord. Abu
और
Hanifa.
उनको कोड़े खाना पड़े कि बनना नहीं चाहते थे.
Yes, yes.
कि मैं इस काबिल नहीं हूँ.
Yes.
उनसे कहा गया आप झूठ बोलते हैं कि आप झूठे को चीफ जस्टिस बनाएंगे.
Yes, yes, yes.
वैसे आप बात ना करें, मगर मुझे इस्लामी तारीख में ये बता दें कि एक अपील का हक नहीं है. कोई ऐसा कानून है या शरई असूल है कि अपील का हक एक दफ़ा काजी ने फैसला कर दिया आखिर है कि अपील का कोई हक नहीं है. ऑफिस ऑफ चीफ जस्टिस बनने का मकसद ये होगा कि अपील का हक है.
Administrative. He was the administrative head
भाई
of all
अपील
the
का हक की
commissions.
बात कर रहा हूँ, अपील के हक की बात कर रहा हूँ.
अपील के हक में my lord pro and contra आ रहा है.
ये प्रो बता दें मुझे, एक कौन बता दें.
الاجتهاد لا ينقض باجتهاد آخر. Once an analogy is made, that cannot be set aside by another analogy. So वो है
वो बात अलग है, वो लोअर और ऊपर फोरम की बात होती है ना. उसमें भी इस्लामिक जूरिस्प्रूडेंस, इस्लामिक शरिया में there were tiers of courts.
But the Qazi al-Qudah, he was the administrative head of the whole judiciary of the time.
जी आप कोई रेफरेंस कहेंगे बस आपने कह दी.
That is
नहीं,
without
कोई किताब का हवाला देना फरमाएंगे या नहीं?
डॉक्टर गाजी साहब अदब
भाई आप कोई किताब देना हवाला देंगे या बस ऐसे ही कह दिया?
डॉक्टर महमूद अहमद
हमें
खाजी
नहीं
साहब की
पता,
किताब
आप
है
हमें किताब दिखाइए.
अदबुल काजी
दीजिए.
मैं दूंगा मैं
कब देंगे?
मैं जनाब को दिस इज
नहीं, कब देंगे?
एकेडमिक क्वेश्चन.
नहीं, ये एकेडमिक अमेरिका के लिए तो एकेडमिक नहीं है, न्यूज़ जर्सी के केसेस को. मगर हम अपनी बारी इस्लाम की बात करते हैं तो फिर एकेडमिक हो जाता है.
ایکڈیمک نہیں، میں نے تو
بتاتے ہی نہیں، پھر آپ ریفرنس دیں نا، پھر ہم لکھیں، نوٹ کریں گے نا.
ادب القاضی محمود احمد، ڈاکٹر محمود احمد غازی my lord. So with these submissions in nutshell
چلیں، تھینک یو.
I'm grateful sir.
کوئی رہ گیا اس طرف؟ اور
Your Honor.
آپ کو سنا نہیں تھا پہلے؟
نہیں بالکل نہیں.
آپ وکیل ہیں یا خود ہیں پٹیشنر؟
ان پرسن.
جی
ان پرسن.
جی.
آپ کی پٹیشن کا ٹائٹل کیا ہے؟
Your constitution petition number 18
جی
محمد شاہدران ایڈوکیٹ ورسز فیڈریشن آف پاکستان.
اوکے.
18 یہ میں نے عرض بھی کیا تھا، یہ 2 پیجز پہ اردو میں ہے.
آپ نے تو کہا تھا پڑھ لیجئے گا، مجھے اور کچھ نہیں کہنا ہے.
نہیں میں نے نہیں کہا.
اچھا وہ کسی اور نے کہا تھا، ٹھیک ہے. ہاں وہ وردک صاحب نے کہا تھا، ٹھیک. 18 نمبر جی فرمائیے.
Your Honor, یہ جو اپیل کے اوپر ہی آ جاتے ہیں زیادہ، جو فوکس کیا ہوا ہے اپیل کو. اپیل کسی بھی ہرارکی میں آپ سیشن کورٹ سے لے کے ہائی کورٹ، سپریم کورٹ، کہیں پر بھی دیکھ لیں، کسی کو حق نہیں دیا گیا ہے کہ ایک کورٹ کے اندر ہی اپیل ہو، سوائے یہ وہ جو لا ریفارم آرڈیننس، لا ریفارم آرڈیننس میں آرٹیکل 199 میں اپیل کا رائٹ دیا، باقی کسی جگہ پر نہیں دیا گیا. ایک بات. اور
وہ لا ریفارم آرڈیننس غلط ہے.
یور آنر میں
کچھ کنکلوڈ تو کریں نا بات کو.
کنکلوڈ کرتا ہوں جناب، لیکن میں ساتھ میں یہ بھی ساتھ میں ایک لفظ
پہلے بتائیں وہ غلط قانون ہے، غیر آئینی ہے، بتا دیں، کہہ دیں یا کہیں کہ ٹھیک ہے.
چلیں یور آنر میں اسی کی ایک اور فردر بات کرتا ہوں.
فردر نہ کہیں، دیکھیں ایسے آرگومنٹ نہیں کریں نا،
میں
آپ
اسی
ایک بات
اپیل کی
کریں، پوری بات کر لو نا.
لیکن جو اس میں اپیل ہوتی ہے وہ سیم ججز کے پاس نہیں ہوتی. اگر کسی نے فیصلہ کیا ہے تو وہ دوسرے ججز کے پاس جاتا ہے.
یقیناً حضور، اس میں تو کوئی دو رائے نہیں ہو سکتی.
ابھی جو آپ لاسٹ میں وہ بات کر رہے تھے کہ اگر 15 ججز فیصلہ دیتے ہیں تو پھر اپیل کس کے پاس جائے گی؟
نہیں ہوگی کسی کے پاس، اللہ تعالیٰ کے پاس ہوگی. پھر
یہی بات ہے نا،
کبھی تو ختم ہوگی نا بات.
بالکل یہ ہونی چاہیے. دیکھیں جی، یہ اس کورٹ سے ایکسپیکٹ کیا جاتا ہے کہ دس از دی ایپکس کورٹ آف دی کنٹری.
اچھا سردار صاحب کہہ رہے ہیں کنٹیمپٹ آف کورٹ میں بھی اپیل ہے، وہ بھی تو اسی عدالت میں.
کنٹیمپٹ آف کورٹ میں جو اچھا چلیں،
اور اس عدالت کا فیصلہ ہے وہ جو کم ججز نے کیا بتایا نا کیا.
انٹرا کورٹ اپیل ہے وکیل صاحب، سندھ میں بھی ہے، یہ سندھ ہائی کورٹ میں بھی ہے. ادھر دیکھیے
جی
1980 سول کورٹ امینڈمنٹ کے تحت انٹرا کورٹ اپیل سندھ ہائی کورٹ میں بھی ہے. سنگل جج کے فیصلے کے خلاف ٹی بی میں اپیل ہوتی ہے، ہائی کورٹ اپیل کہلاتی ہے وہ. لاہور میں، اسلام آباد میں آئی سی ہے انٹرا کورٹ اپیل،
بالکل
انڈر دی لا ریفارمز آرڈیننس 1972. تو وہ جج تھوڑی سنتا ہے جس نے اوریجنل فیصلہ کیا ہوتا ہے، وہ تو ڈی بی بنے گی، سنگل کا فیصلہ ڈی بی میں جائے گا اپیل میں.
سیم ججز کے پاس نہیں جاتا ہے. آئی سی میں ججز ڈفرینٹ ہو جاتے ہیں.
ظاہر ہے ڈفرینٹ ہوں گے نا، تو یہاں بھی ڈفرینٹ ہوں گے نا.
ایک تو یہ ہرڈل
اگر یہاں پہ 184(3) میں 3 ججوں نے ڈیسائیڈ کیا ہے اور رائٹ آف اپیل دی گئی ہے، تو وہ 3 تھوڑی بیٹھیں گے اس میں سننے کے لیے.
ریویو میں وہی سنیں گے، اپیل میں کوئی اور سنے گا. یہ تو ایک، یہ آپ چاہتے ہیں ہم تو یہ تو ہم تشریح کر دیں گے، یہ تو آبویس سی بات ہے.
بالکل اس کی تشریح بھی ہونی چاہیے.
اچھا ٹھیک ہے، اور کیا پوائنٹ ہے آپ کا؟
یور آنر تمام اپیلیں جو ہیں جو اس کورٹ میں ہوتی ہیں، تمام اپیلیں جو اس کورٹ میں ہوتی ہیں، ٹربیونل کی اپیلیں 212 میں یا جو بھی کنٹیمپٹ میں ہوتی ہیں، وہ تمام اپیلیں جو ہیں 185 کے ساتھ ہوتی ہیں. 185 کے علیحدہ نہیں ہوتی، اس میں ٹائٹل 185 ہوتا ہے ریڈ وتھ. تو کیا 184 کو بھی 185 میں ہم لائیں گے؟
اب سوال پوچھیں گے، ہم جواب اپنا ججمنٹ میں آپ کو جواب دے دیں گے.
یہ بالکل یہ میں نے ریز کر دیا نا جناب، میں نے ایک آئینی سوال ریز کر دیا نا.
ٹھیک ہے، ہم جواب دے دیں گے آپ کو.
آج تک جتنی اپیلیں ہوئی ہیں نا سپریم کورٹ میں نے وہ اس کا پتہ کر کے آیا ہوں کہ وہ میں اے آر سے بھی پتہ کیا کہ وہ 185 میں ہی آتی ہیں، چاہے وہ
ٹھیک.
تو آپ کہنا کیا چاہتے ہیں کہ آپ کہتے ہیں کہ ان کو تو اپیل کی ریمیڈی ہے کہ 184 میں ہونی چاہیے یا نہیں ہونی چاہیے، یا 184
میں یہ کہنا چاہتا ہوں کہ اگر دیکھیں نا 212 جو ایک آرٹیکل ہے
اس میں اپیل ہے، اس کے بارے میں کیا کہتے ہیں؟
اس میں اپیل ہے، تو اس میں کیوں نہیں دی گئی؟ پھر 184 میں کیوں نہیں دی؟ جنہوں نے دیکھیں یہ جو آئین بنایا ہے یہ کانسٹیٹیوئنٹ اسمبلی نے
آپ جواب سننا چاہتے ہیں، ذرا جواب لمبا ہو جائے گا.
جی
پھر اگر یہ جواب آپ کو شاید پسند ہی نہیں آئے.
نہیں، میں اس کے لیے بھی تیار ہوں.
اچھا سن لیجئے پھر.
ہاں،
یہ ایشو کبھی پہلے کیوں نہیں رائز ہوا؟ 73 کا آئین ہے نا.
یور آنر
184 کا اختیار 184(3) کا جو اختیارات زیادہ استعمال کیے گئے کب استعمال کیے گئے؟ 73 میں، 74 میں، 75 میں، 76 میں، 77 میں کب پہلا اختیار استعمال ہوا؟ وہ ہوتا تھا ایک جنرل لوگوں کی انفورسمنٹ آف فنڈامنٹل رائٹ کے لیے، ٹھیک ہے نا؟ اب شاید ہم نے تجاوز کر دیا خود ہی 184(3) میں سے، شاید، یا تو آپ کہیں نہیں کیا، آپ کے سارے ججمنٹ 184(3) کے بہت اچھے ہیں، مفید ہیں، سب کے لیے فائدے مند ہیں، وہ تو ایک بحث ہوگی۔ تو جہاں ہم تجاوز خود کر رہے ہیں، آپ نے کہا کر تو دیا تو خیر ہے، مگر اس کا کوئی سلوشن بھی نہیں ہے، صرف آئین کو آپ ترمیم کر لیں۔ آئین میں ترمیم کرنا ایسا آرام سے بات کہنا، آپ 2/3 اکثریت لائیے نا، آپ یہاں کر کے کھڑے ہو کر کے باہر کے الیکشن لڑنا ایک مشکل ہو جاتا ہے جیتنا، وہاں 2/3 الیکشن لانا کوئی آسان کام نہیں ہوتا ہے کہ پارلیمنٹ میں جی کر لیں، صرف کانسٹیٹیوشن امینڈمنٹ کر لیں۔ تو پہلے آپ کہیں کہ جی تجاوز تو آپ نے کر لیا، اس پہ تو اس کو تو چھوڑ، میں وہ جملہ نہیں استعمال کرنا چاہتا ہوں جو عام فہم میں استعمال کرتے ہیں، وہ تو ہو گیا درگزر کریں، مگر غلطی تو کر دی۔ اب ہماری غلطی صرف 2/3 پارلیمان کر سکتی ہے، 3 ججز کی غلطی یعنی کہ 400-500 لوگ جتنے بھی ہیں پارلیمنٹ میں، سینیٹ میں، دونوں میں ملا کر کے، شاید صوبوں والے بھی آ جائیں اس میں، وہ صرف کر سکتے ہیں۔ یہ ٹوٹل آرگیومنٹ ہے یا کوئی اور بھی بہتر آرگیومنٹ ہے اس کے علاوہ؟ یا تو آپ کہیں کہ سارے فیصلے 184(3) کے درست ہیں، یہ تو پھر میں آپ کی بات مان لیتا ہوں، حتمی ہو گئے، ختم ہو گئے، چھوڑو آگے بڑھتے ہیں، یا کہیں غلط بھی ہیں؟
یور آنر، جو پبلک امپورٹنس کا لفظ استعمال کیا گیا ہے وہ 184 میں استعمال کیا۔
سارے فیصلے درست ہیں یا غلط ہیں؟
میں اسی فیصلوں کی بات کر رہا ہوں، پبلک امپورٹنس کا فیصلہ ہونا چاہیے، میں یہی عرض کرنا چاہ رہا ہوں، مفاد عامہ کا فیصلہ ہونا چاہیے۔
جواب ہی نہیں دینا چاہ رہے ہیں؟
میں تو اس کا جواب مفاد عامہ کا فیصلہ ہونا چاہیے، مفاد خاصہ کا فیصلہ نہیں ہونا چاہیے، خاص لوگوں کے لیے،
جو آپ
خاص لوگوں کے لیے نہیں فیصلہ ہونا
ججمنٹ،
چاہیے۔
رپورٹڈ ججمنٹ جو ہیں آپ کے خیال میں سارے درست ہیں؟ اب اس پہ جواب ہی نہیں دینا چاہتے؟
میں نے کافی پڑھی ہیں، کافی حد تک درست ہیں، اس کو میں ڈیفینڈ کرنے کے لیے بھی تیار ہوں۔
ٹھیک پھر تو یہ کہہ دینا سارے درست ہیں،
بالکل
سارے درست ہیں، صحیح ہے۔
اب شاید میری نظر سے کوئی وہ ججمنٹ نہ گزری ہو،
بس آپ کا موقف لے رہا ہوں،
میں نے
حضور آگے پڑھیے۔
میں یہ کلیم نہیں کرتا میں نے ساری ججمنٹ پڑھی ہیں،
ٹھیک ہے،
جو میں نے پڑھی ہیں اس کے مطابق میں ان کو صحیح سمجھا ہے، اور وہ انٹرپریٹیشن جو ہے
اگر کل آپ باقی ججمنٹ جو آپ نے نہیں پڑھی آپ پڑھ لیں اور آپ اس نتیجے پہ پہنچے کہ وہ تو صحیح نہیں ہے، پھر کیا ہوگا؟
اگر وہ نہیں ہوگی تو اس میں جناب ریویو کا جو کانسٹیٹیوئنٹ جنہوں نے بنایا ہے انہوں نے ریویو کا رکھا اسی لیے ہے کہ اس کو ریویو کیا جائے۔ اب میں تو جناب اس میں سے وہ
آگے بڑھیں، دوسرا پوائنٹ کوئی ہے آپ کا؟
اچھا،
ہم دوسرے لوگوں کو سنیں نا، بہت ٹائم نکلے گا۔
اس میں جناب میں وہ
قانونی اور آئینی بات کریں،
میں اسلام کی بات بھی کرتا ہوں۔ دین ہمارا جو سٹارٹ ہوتا ہے
کریے، حوالے دیجئے۔
میں دین جہاں سٹارٹ ہوتا ہے جب اللہ تعالیٰ نے انسان کو بنایا، جب اللہ تعالیٰ نے انسان کو بنایا تو فرشتوں نے جب اعتراض کیا تو اللہ تعالیٰ نے ان کا جواب دلیل سے دیا اور ان سے پوچھا کہ ہاں بھی ان کے آپ نام بتائیں، تو حضرت آدم علیہ السلام نے بتا دیے اور تمام نے سجدہ کیا الا ابلیس۔
پلیز ایسے تو نہ کریں نا، کوئی حوالہ دے کسی بات
تو اللہ یہ کہ انہوں نے بھی دلیل اللہ تعالیٰ نے ان کے سامنے رکھی،
یہی تو ہماری بھی بات ہے۔
تو یہ جو ججمنٹس ہیں ہمارے فیصلے وہ بھی دلیل پہ ہونے چاہیے،
اگر نہیں ہو
میں اسی کا کہ سٹارٹ ہی جو اللہ تعالیٰ نے فرمایا وہ دلیل سے فرمایا ہے،
صحیح ہے۔ اس
کے علاوہ اور بھی کئی اس میں قرآن میں حوالے ہیں جو دلیل پہ بات کی ہے، حالانکہ اللہ تعالیٰ فرما دیتے کہ جی میرا نالج ہے، کس نے انکار کرنا تھا؟
ٹھیک ہے،
تو وہ جب ایک مالک ساری دنیا کا وہ دلیل سے بات کر رہے ہیں تو سب کو دلیل سے بات کرنی چاہیے۔
یہ تو بات اپنے خلاف آپ کر رہے ہیں۔
میں دلیل سے بات کر رہا ہوں جناب،
آپ کی بات نہیں کر رہا ہوں، آپ کہہ رہے ہیں کہ ایک دفعہ فیصلہ آ گیا تو حتمی ہے، چاہے اس میں دلیل ہو یا نہ ہو، حتمی ہے۔
یور آنر، ایک اپیل نیچے سے آتی ہے، آتے آتے ہم یہاں تک کتنے سالوں میں، کتنی صدیوں میں پہنچتے ہیں۔
پھر آپ یہ ادھر ایسی ڈسکشن کر رہے ہیں، پھر اگلے کو سنتے ہیں، کوئی جنرل باتیں نہ کیجیے نا پلیز۔
دوسرا جناب، یہ ایک تو یہ اپیل کے بارے میں جناب میں نے عرض کیا،
آگے بڑھیے پلیز
جی۔
اچھا،
184 اور 185 دونوں میں کہیں سبجیکٹ ٹو لا اور سبجیکٹ ٹو کانسٹیٹیوشن نہیں کہا گیا، نہ 184 میں یہ بات ہے اور نہ 185 میں۔ اور یور آنر، یہ جو انہوں نے اختیار دیا ہے کہ یہ کمیٹی بنے گی اور کمیٹی جو ہے اس کا فیصلہ کرے گی، आइन ये कहता है ये इख्तियार जो चीफ जस्टिस को दिया गया वो पूरी सुप्रीम कोर्ट ने दिया है, रूल्स बनाकर रूल्स के तहत ये चीफ जस्टिस को इख्तियार दिया गया है। अगर चीफ जस्टिस साहब इस इख्तियार को कर्टेल करना चाहते हैं तो बेहतर होगा कि वो उसी सुप्रीम कोर्ट के पास जाएं, कमेटी में बैठें और वहां पर फैसला करवा लें, 2 का जी कि 2 करेंगे।
सही है, ठीक। बस अच्छा, अगर ये यहाँ पढ़ के तैयारी करेंगे तो हम नहीं सुनेंगे। नेक्स्ट आप ऐसे नहीं होगा ना, आप समझ रहे हैं बस हम कैप्टिव हैं जो
मैं तो बिल्कुल मुख्तसर अर्ज
तो कर दीजिए ना, पढ़ के आप सोच रहे हैं जल्दी जल्दी बताएं ना
जो पॉइंट्स मैंने लिखा है जो मैं
हम पढ़ लेंगे। अगर आपने इसमें एक लफ्ज लिखा है इस पूरी एक कागज की आपकी दरखास्त है टोटल
दो सफ़ों की, दो सफ़ों की,
चलिए 2 मान लिए।
अच्छा ये जनाब वो जो ये बार बार ये जो इसका लोकस स्टैंडाई की बात की जा रही, फंडामेंटल राइट्स कंसर्न फ्री जो है, तो इसके बारे में मैं सिर्फ एक लाइन में जवाब देना पसंद करूँगा कि मेरा राइट है कि हर काम कानून और आइन के मुताबिक हो।
चलें सुन ली, आइए।
और बेंच पूछना चाहते हैं सवाल तो मैं हाजिर हूँ।
सर मैं कॉन्स्टिट्यूशनल पिटीशन नंबर 6 में हूँ, न पिटिशनर हूँ न रिस्पॉन्डेंट हूँ, जमात इस्लामी की तरफ से हूँ और सिर्फ नोटिस आया पार्टी को। तो इस
आप अगर आप इसको अपोज कर रहे हैं कानून को फिर सपोर्ट वाले बाद में सुनेंगे। आप जगह दे दें प्लीज, सपोर्ट वालों को बाद में सपोर्ट वाले बाद में सुनेंगे अटॉर्नी जनरल के साथ। जी आप कर चुके हैं, कोई और रह गया? आइए इधर से कौन नहीं, आप उस दिन चले गए थे। अटॉर्नी प्लीज डोंट इंटरप्ट। अटॉर्नी जनरल, विल यू लीड द आर्गुमेंट्स और विल यू रिस्पॉन्ड टू द आर्गुमेंट्स?
Yes, I will respond, my lord. Mr.
Sir, this is very unfair.
will go
My lord, the chief justice, this is very unfair. आपने कहा था कि अटॉर्नी जनरल साहब को आर्ग्यू करने दें, हम आपको बाद में सुनेंगे। अब आप
दिखाइए, ऑर्डर शीट दिखाइए।
ये दिखाइए। This is very unfair. I will not argue if you don't want to hear me, but don't put things which are factually incorrect.
वैसे अगर कोई बात कर रहे तमीज से कोई हर्ज होता है? वैसे
नहीं सर, आप
सुन लीजिए, आप
अपने असलूब को देखिए,
आप अपना
अपने असलूब को देखिए, फिर आप हमारे मुतालिक बात कीजिए।
देख लेते हैं।
आपका अपना असलूब ठीक नहीं है। ख्वाजा तारिक रहीम साहब ने इसी वास्ते आ जाने से इनकार कर दिया क्योंकि योर लॉर्डशिप वाज वेरी अनकाइंड टू हिम।
प्लीज डोंट argue on behalf of those who are not present.
Sir, he is my colleague. He has instructed me to inform you this.
सुन लीजिए, ये सब जजेस ने साइन किया है। Mr. Imtiaz Rashid Siddiqui, representing the petitioner in Constitution Petition number 6 of 2023, who was partly heard on the last date of hearing, states that he does not want to add anything further and that his written submissions may be read.
कौन सा order है?
Thank you very much. Now please take your seat.
Mr. Zahid Ibrahim.
I must lodge my protest.
Please
on
take your
lordship.
seat before I issue something. Please take your seat.
Mr. Zahid Ibrahim, followed by Mr. Saladin.
It's as you wish. If you want to go last,
I'll go last, my lord.
As you wish. Everybody who comes, please introduce themselves. Who are they for?
I'm representing PMLQ.
Have you filed anything?
Yes, my lord, I filed CMA 3991 of 23. I'll be very brief, my lord.
3991
of 23. My lord, I'll be very brief and to the point.
Take second, just let us get it out. CMA.
What is CMA number, right, sir?
My lord, 3991. May it please your lordship. We've heard
Do we
various...
need to have it before us or we don't need to have it before
My
us?
lord, if I do, I'll sort of, to a very limited extent, I'll refer to that later. If I may just address, my lord, that we are trying to understand the various meanings hidden within the few articles of the Constitution. In order to do so, the basic rules of interpretation which, according to this honorable court, are to be utilized in reading and understanding these provisions first, let us just identify that. How are we to read these articles? My Lord, the Honorable Supreme Court in the Sui Southern Gas case, 2018 SCMR 802.
802.
802, my Lord. The court summarized.
Have you given a paper poke or something with these?
My Lord, ये तो judgments.
Judgments.
Judgments की मैंने
just
I'd
given
given
a
the
list.
list. I'd given the list in the morning.
Okay.
Yeah, you mentioned it in paragraph 3 of your CMA. In the case of Sui Southern Gas.
My Lord, because
You have
I just
reproduced.
I want to read the just
Pardon me.
one sentence from the judgment.
Relevant page?
My Lord, relevant page is at 830.
830.
830. What the court did here was it looked at all the case law, it looked at all the treaties from A.K. Broi Saab's to Justice Fazl Karim's to Servai Saab's, and it summarized the rules on how we are to interpret Constitution. And my Lord, those rules are summarized on page 830. A through I.
830.
I will not read all of those, but on the next page, 831, the Supreme Court cites with approval a judgment, and that is at paragraph 14b. Uska ek, I mean, that sentence really encapsulates how we are to read these provisions. My Lord, paragraph 14b. It's a Indian Supreme Court case which has been cited, and it says, the cardinal rule of interpretation, however, is that words should be read in their ordinary, natural, and grammatical meaning, subject to a rider. First rule is cardinal, ordinary, natural, grammatical meaning, subject to this rider. My Lord, I'm reading from 14b, paragraph 14b. Subject to a rider. That in construing words in a constitutional enactment, conferring legislative power, the most liberal construction should be put upon the words so that the same may have their effect in the widest amplitude. This is the basis on which we are to interpret these provisions of the Constitution. My Lord, with regard to entries.
Mr. Ibrahim, this principle is applicable in all eventualities?
My Lord, that is what this judgment says. And I'm just setting out the basic rule that the Supreme Court has set out. And then, my Lord, at page 838,
there is absolutely no departure from this?
No, obviously, my Lord, we make departures when we are reading and in trying to interpret. But a basic rule is set out. First of all, you determine what are the rules of the game on how do we read these provisions. And one of the rules that it says...
You see the situation which has arisen out of the proceedings which have been going on, whether this en bloc interpretation is applicable?
In my view, yes.
This, how come?
In my view, yes. And I'll come to that. My Lord, on page 838, entries of the legislative lists on how they are to be read are also, the rules on that have been summarized. And if we see 838, the rule set out in paragraph 2, In construing the words in an entry conferring legislative power on a legislative authority, the most liberal construction should be put upon the words. 3. While interpreting an entry in the legislative list, it should be given widest possible meaning and should not be read in a narrow or restricted sense. 4. Each general word in an entry should be considered to extend to all ancillary or subsidiary matters which can fairly and reasonably said to be comprehended in it. My Lord, if we read these provisions, now coming to the matter at hand, my reading in relation to the practice and procedure part of this law, I'm not referring to the appeal part, the practice and procedure part. My Lord, the legislative competence, in my view, arises from Article 142A, where the Parliament can make exclusive power to make laws in respect of matters in the legislative list, federal legislative list. From Article 142, I look at the federal legislative list and I look at entry 58. Entry 58, matters which under the Constitution are within the legislative competence of the Parliament or relate to the Federation. Matters which under the Constitution are within the legislative competence of Parliament.
You see, if you
what are the matters?
Go by that argument, then there is no need for any other entry in the legislative list. Just one. This one article, this one entry would cover everything.
With, if I may answer your Lordship's question, that does this provide then complete free hand? No. It is only to the extent, the language is very clear, sir, and it's not all encompassing. It says matters which under the Constitution are within the legislative competence of Parliament. What is within the legislative competence of Parliament? Article 191, and this is where subject to law comes in, and the reading of that provision. So what I'm doing is,
what do you mean by, Mr. Zahid?
My Lord.
Entry number 55 is not applicable here.
No, entry number 55 is also. Because, and I'll come to that. Because entry number 55...
The legislation has been made in both entries.
In both, yes. Yes, and I'll come to that.
Mr. Zahid Ibrahim, what is then your argument in relation to the judgments which have been cited?
Yes.
That subject to the Constitution and subject to the law as mentioned in Article 191 is a restrictive provision. It is not a provision which confers jurisdiction or confers powers. It restricts. What's your response to that?
Can you please do respond to the queries, but can you just complete your thought, because my pen has been left in the air. I don't know what you're going to say next. Suspense is killing me.
Your Lordship's observation.
Respond to them.
Because I will respond to it because I have, I will refer to Justice Anwar Bhinder's case and try to express my view on this for your Lordship's consideration. So what I was saying is that in 142, entry 58, entry 55, and then you look at Article 191, where subject to the Constitution and law, Supreme Court may make rules regulating the practice and procedure of the court. Now, the argument being made by those who are challenging this law are saying that once the Supreme Court has made rules, then the door closes. Then there is no subject to law. You cannot do this. My submission to this Honorable Court on that will be that this court, in Justice Anwar Bhinder's case, has said the opposite. In Justice Anwar Bhinder's case, where it was looking at Article 188 there, the power to review. What did Justice Anwar Bhinder's case hold. My Lord, this is PLD 2010, Supreme Court 483.
Which paragraph do you?
My Lord, there are two paragraphs in this, my Lord. First, I would like to refer to page 523, 522 and 523. My Lord, paragraph 25. After reproducing Article 188 of the Constitution, where Supreme Court has been given the power subject to provisions of any act and of any rules made by the Supreme Court to review any judgment pronounced or any order made by it. Paragraph 25 says, a bare perusal would reveal that it has been couched in a very simple and plain language, hardly necessitating any scholarly interpretation. It inter alia provides that the Supreme Court has power to review its judgment or order subject to the provisions of any act of parliament and any rule made by the Supreme Court itself. The contention whether the Supreme Court rules are subservient to the Constitution have been discussed in a later part of this judgment. Now this, my Lord, the next sentence is critical. Critical. It says, it is to be noted that no act of parliament whatsoever has been promulgated, and thus it can reasonably be inferred that legislator does not want to restrict or impose any condition on the powers conferred upon this court under Article 188 of the Constitution. In fact, the words subject to provisions of any act of Majlis-e-Shura and any rules made by the Supreme Court are indicative of the fact that indirectly the powers so conferred have been enhanced, and there was absolutely no intention for curtailment of such powers conferred upon this court under Article 188 of the Constitution.
This is what it is being said, that because you see, if you read on in paras 36, 37, the discussion is that even the power of the court is to enhance the power. It's not to curtail it.
My Lord,
you can't just read one sentence out of it.
But at least one sentence we have to read also.
You can't read one sentence when the context is provided by the immediately following sentence. How can we read a judgment?
I'm not seeking that.
आप आगे जाके पैरा 36 तो पढ़े ना, 36, 35, 36.
सर मैं पैरा 36 भी पढ़ लूंगा. मेरा सिर्फ ये कहना है कि जब सुप्रीम कोर्ट ये कह रही है,
एक जुमले से तो बात
नहीं जरूर.
Let me come back to.
आप अपना आर्गुमेंट तो कंप्लीट कीजिए.
आर्गुमेंट प्लीज कंप्लीट करें. Entry 58.
आपका आर्गुमेंट है क्या? मैं नोट करूं.
Let me come back to entry 58 first. आप कह रहे हैं कि matters under the Constitution are which are within the legislative competence of Majlis-e-Shura Parliament or relate to the Federation.
My Lord.
This should be given the broadest possible meaning.
Yes.
And you relate this to the rules, well-settled rules of interpretation that you have already read out.
Yes.
And you relate this back now to law.
Yes.
As my learned colleague has already said, that this begs the question whether that is an enabling power. But my question is slightly different.
My Lord.
जो rules of interpretation जो आप जिनका जिक्र कर रहे हैं और जिन judgments का आप जिक्र कर रहे हैं, as far as I am aware, those are concerned where the grant of legislative competence was by the entry itself. Okay? The grant was, that is the context in which those judgments are given. Okay? Now, as you are aware, an exclusive legislative list, whether Federation or even the provinces, 35 Act, 56 Act, we don't need to go into that. An exclusive legislative list, especially now in the context of 73 Constitution as it presently stands, has two effects. One is positive. The legislative entry confers a power, a legislative competence.
but the other is negative. The negative is that it excludes the other legislatures from making any such law. So if you look at it and interpret it in the broadest possible terms, which is the correct way to interpret these entries, it has two effects. It describes constitutionally what is the scope of the legislative grant that is being conferred positively. Negatively, it excludes the other. I put it to you that if 58, which does not itself confer any legislative competence, the effect and purpose of this is not positive, but really negative. To clarify, to put it in the absolute clearest possible terms, that whatever power, legislative power, is given not in these entries, no, in the Constitution itself. Article 151, Article this, that, the number of judges of the Supreme Court, so many other examples can be given. That has, Article 58 is making clear, no intrusion by the provinces, none whatsoever. This is an exclusive grant to Parliament. So therefore, and I put it to you, that the way you are looking at it, it seems to me, with all due respect, and relying on those principles of interpretation, is perhaps not correct, because this is not a grant of legislative competence. It is merely shielding a grant made elsewhere, outside, other than on the legislative lists. It is shielding that from any possibility of encroachment by the provincial legislature. So that is its true purpose. What would you say to that?
जाहिद साहब, इससे पहले कि आप यकीनन इनके हमारे मोहतरम दोस्त का जवाब दें सवाल का, मगर मेरा फिर कलम हवा में रह जाता है। आपका अगर मैं एक दफ़ा लिख लूँ आपके पॉइंट क्या है, फिर ज़रा मुझे समझ आएगा, फिर बेहतर आप जवाब भी दे सकेंगे। ज़रा आप अपनी बात कंप्लीट कर लें, फिर जवाब ज़रूर दीजिएगा, नोट कर लीजिए।
So the point I was making, that yes, you read this entire judgment together.
Proposition बता दें,
proposition is
अपनी proposition दें, judgments, you know this is the full court. आप अपना view हमें दें, आपका view क्या है?
My lord, मेरा view ये है कि जस्टिस अनवर भिंडर्स केस में सुप्रीम कोर्ट ने ये फैसला किया है 188 को इंटरप्रेट करते हुए कि क्योंकि पार्लियामेंट, जहाँ सब्जेक्ट टू लॉ लिखा है, क्योंकि पार्लियामेंट ने कानून नहीं बनाया है, उसका ये मतलब नहीं है कि रूल्स विल कंटिन्यू टू होल्ड द फील्ड एंड देयर कैन नॉट बी एवर एनी लॉ. माय submission is, my reading of Justice Anwar Binder's case is that this case itself acknowledges that Parliament has not made but can make law. That is my point.
Are you saying that the judgment is interpreting legislative competence through subject to law and constitution? So where in the judgment exactly does it say subject to should be read as enabling granting legislative competence?
No, my ladyship, all I am saying is, because justice in this case, again the issue was that there was no law. There was made by Parliament in relation to, for instance, abhi jo review of judgments ka law aaya tha and which has been struck down. All I am saying is that the court, when looking at Article 188 at that time, all it was saying is, listen, there could have been a law, there isn't, but we are not trying to say that there can never be.
But please look at the wording of 188. It's very different from 191.
Exactly.
It doesn't say subject to. एक second जी, आप कह रहे हैं subject to the constitution and the law को हम enabling पढ़ें as a source of legislative competence, and you want us to rely on the Anwar Bhinder case in pursuance of this point, which is reading an article which does not say subject to. It is an article which actually says the Supreme Court shall have power subject to the provisions of any act of Majlis-e-Shura. It is saying that that act of Majlis-e-Shura and of any rules made by the Supreme Court. So there is a difference. This is a question that we've been working our way around, that what's the difference between an act of Majlis-e-Shura and the law. There is a difference. When you read subject to the law as an enabling provision, you bring in that executive action like an ordinance. You bring in that many other forms. So you're saying that the Supreme Court rule-making power becomes subservient to all those sources of law that exist, that the Constitution recognizes as being part of the law. So hence, can you explain through this judgment how that helps your point?
My Lord, my ladyship, first of all, when we say law, it certainly includes an act of parliament. And I acknowledge that 188 is different from 191. In 188, in fact, the Supreme Court has been given the power of review. In 191, there is no power. There is only acknowledgement that Supreme Court may make rules.
There is a power
the language
given
is
to
different.
The Supreme Court. It's
My Lord, the language is different.
Power conferring article which empowers the Supreme Court to make rules. And then a judgment of this court, again, it's, I think in the NRO judgment, which says rules framed under constitutional powers, i.e. the 1980 Supreme Court rules, stand on a higher pedestal compared to ordinary legislation. What does that mean?
If I may, with utmost respect, I know your lordship in the Ghulam Mohiuddin case recently rendered judgment where the Supreme Court review law was held to be illegal. Your lordship has expressed exactly that point.
No, this is not our expression. That is a reliance on an earlier judgment of this court which says this.
My Lord, all I was trying to point out that the language of 188 and 191 in granting powers to the Supreme Court uses very different languages.
But you see, even this judgment that you're relying on, this also says that the Supreme Court rules are on a higher pedestal and promulgated on the basis of a mandate given by the Constitution.
Thank
you.
you.
Exactly yahi keh raha hai.
Thank you for pointing out. Let me again, in relation to this judgment also, now clarify what this judgment has actually said and what it is purportedly argued that it has said.
No, argument apart, as Ladyship also pointed out, and as has been mentioned earlier, the judgment that you rely upon in itself lays down this, the ratio of the judgment is that the rule-making power, when exercised, when the rules are framed, then such rules stand on a higher pedestal for the reason that those rules have been framed in exercise of powers granted by the Constitution itself. And the powers granted by the Constitution under 191 are the powers granted by the Constitution to the Supreme Court and not to any other organ of the state.
My Lord, if we can just see page 536 of this judgment, on this point alone.
Before you come to 536, just one quick question. This sentence that you have read out to us from page 523,
yes,
which you regard as critical, is it your understanding that this is part of the ratio of the judgment?
Yes.
This is para 25 head note K जो है ना आपका इसमें पढ़े नहीं. In fact, the word subject to the provisions of any act उसको define किया इन्होंने.
जी सर मैं
बिंडर वाले केस में.
हाँ मैं एक सेकंड.
जाहिद साहब आप चले आर्गुमेंट तो अपना करें ना.
जी. So I was trying to yes, page 536 of the judgment, my lord, of the same judgment.
Mr. Zahid.
जी पढ़िए.
Paragraph 36 is more relevant.
सर मैं उसी पे आऊँगा सर, अगर एक सेकंड के लिए. ये हायर पेडेस्टल वाली जो बात है, 530 पेज 536 पे फर्स्ट पैराग्राफ. The Supreme Court rules are on a higher pedestal and promulgated on the basis of mandate given by the Constitution itself and not by a government, object whereof was to enhance the power of review as conferred upon the Supreme Court under Article 188 of the Constitution. One more time, just the first part. Supreme Court rules are on a higher pedestal. Higher pedestal than what? ये इसके जो preceding paragraph, preceding page है, अगर हम उस पे जाते हैं,
इसलिए कहा है कि रिव्यू में पावर बढ़ाए में रूल्स ने.
सर इसमें ये
I'm trying to understand, Mr. Zahid Ibrahim. Please, can you complete your thoughts? Take the questions, note them. If you keep responding to every query, I don't know what you're going to say next.
Okay, my lord. All I was the point.
Again, you were on 236 AA.
The point that I'm making is that in this judgment, when the Supreme Court says that the rules are on a higher pedestal because they are made under constitutional sanction, what are they saying? Higher pedestal than what? Higher pedestal than law or something else? They are saying higher pedestal than rules made on the basis of another statute.
No.
And if I may just complete,
If you would also read the NRO judgment, this point has further been elaborated by this court by saying once these rules are made, any subsequent legislation we may not follow. And we need not follow.
मेरी सिर्फ आपसे ये गुजारिश है कि यहाँ पे जो conclusion हुआ है full court का in relation to the Supreme Court rules being on a higher pedestal, that is not on a higher pedestal as compared to any law. And the reason why I say this is evident because this discussion started from page 500.
Can you just complete your thoughts?
Page 534 at the bottom of page 534.
Para 37.
Para 37, my lord. Exactly.
So Zahid, para 36 is very important.
चलिए, Zahid साहब, please argue करिए as you want to.
So para 37 का ये, I'm just reading.
Zahid साहब, अगर मैं आपसे सवाल ऐसा पूछूं जिससे मैंने फैसले ही कर रहा हूं तो आप कहें फिर सवाल ही नहीं बनता है. आप अपना आर्गुमेंट कर लें कंप्लीट, फिर हम आपसे सवाल पूछ लें.
I mean, I honestly feel that today, I mean, I'm trying to answer questions.
आप पहले आर्गुमेंट अपना कंप्लीट कर लें ना.
They help in this debate. So I was just wanting to read para 37 from the bottom. मतलब जो in Roman font है उससे पहले वाला एक sentence. A line of distinction. In this regard, reference may be made to the case of Federation of Pakistan, Saeed Ahmed, PLD 1974. A line of distinction is to be drawn between statutory rules made by the executive pursuant to an act or an ordinance and statutory rules made by the Supreme Court pursuant to the mandate of Constitution as conferred upon it by Article 188 of the Constitution. ये जो sentence है, my lord,
a line of distinction.
A line of distinction is to be drawn between statutory rules made by the executive pursuant to an act or an ordinance and statutory rules made by the Supreme Court pursuant to the mandate of the Constitution as conferred upon it under Article 188 of the Constitution. That is what is being...
Ajay, can you now go back to 536 AA?
If this line of distinction is drawn, Mr. Zahid Ibrahim, if this line of distinction is drawn,
yes,
that which means that the rules made under 188 are of a different category altogether, then there's no need to say that those rules are at a higher pedestal. Then those rules and rules made which are normally called subordinate legislation fall into two different categories. It seems to me that the passage, that those words that you have just read out from page 536 on a higher pedestal is not vis-a-vis a category that the Supreme Court in the words that you have just read out,
my lord,
say fall into a totally separate and distinct category. And if this is correct, then the higher pedestal can surely be only vis-a-vis law and not subordinate legislation or rule-making power, which is of a totally different nature. Would that not be a proper reading of the judgment as a whole?
Perhaps, like the first sentence of paragraph 37, in fact, perhaps answers what your lordship is saying. Supreme Court itself says, in view of the above discussed principles of interpretation, it seems immaterial to discuss whether the Supreme Court rules are subservient to Article 188 of the Constitution. They say that is an immaterial argument, where it draws a comparison and says that they are on a higher pedestal. That is only in relation to rules made under some other statute. That is the point. My lord,
and if we go back to 536AA, now if we are to read this line disjunctively, object whereof was to enhance the power of review as conferred upon Supreme Court under Article 188 of the Constitution, then if we go to read it like the petitioners want us to read it, that would mean that the Supreme Court is not bound by Article 188 either, because it's giving it more power than the Constitution itself. Surely that cannot be the case. So it has to be read in context to the line that you read. I don't know.
I understand that, we are all pressed for time. I don't want to sort of...
हम पढ़ लेंगे पूरा judgment.
My lord, the next point I want to make is in relation to the appeal.
But before you go to appeal, what do you say about entry 58 on which you rely upon? That entry 58 is, since it is not conferring legislative competence, the rules that you rely upon, rules of interpretation, the purpose of entry 58 is the negative aspect of those rules, to make sure that a competence given elsewhere other than the lists, that is totally outside the scope and power of provincial legislature. That's all that the purpose of 58 is. It does not confer legislative competence, and therefore the principles that you rely upon really don't apply. What would you say to that?
My lord, my response to that would be that...
Zaid sahab, बहुत अच्छा सवाल है. Shall we take the break now, and you have received a number of queries, just mull them over, but then you just be precise in your answers, because we will hear you, don't worry. So we can take a slightly longish, make it this lunch break as opposed to 1:30 and the prayer break or whatever you want to make it. Just make these questions are very valuable for food for thought, and then mull them over and respond to us.
I promise.
We will just come back in half an hour. Is that all right?
I promise to continue, but I can't promise to be able to have all the answers to the questions posed.
You've seen what's been happening these last days.
Yes.
You should be ready for that.
I've tried, my lord.
आप लोग भी जरा repetition ना कीजिएगा, कोशिश कीजिएगा, नई बातें कीजिएगा जो इन्होंने नहीं की हैं. चलें, ऐसा होगा.